Okay, so don't mix up defendant being present at the trial with defendant being present at sentencing. So, presence at sentencing, the waiver also has to include the maximum sentence that may be imposed, and that he waives his right, and it's got to be written in subscribed statement and has nothing to do with the DA. So, that's totally different than the section where they talk about entering the plea to guilty in person and plea to an information.
Okay. If an action is adjourned in contemplation for the referral to the dispute resolution center, it's the thing with the felony. Notification must be no later than 45 days after action was referred to such dispute center. If the defendant has agreed to pay a fine, then the district attorney must advise as the status of the fine every 30 days. 30 days. And then we have another 45-day rule that is with the forfeiture of bail to the county clerk. Where is it? If cash bail is forfeited, the county treasurer shall give written notice of the forfeiture to the person who posted cash bail for the defendant. The county treasurer may, at any time after the final adjournment or 45 days after notice of forfeiture has been given, whichever comes first, apply the money deposited to the use of the county. The county treasurer may, at any time after the final adjournment or 45 days after notice of forfeiture has been given, whichever comes first, apply the money deposited to the use of the county. The felony complaint is promptly transmitted to the Superior Court. That means transmitted. I keep saying transferred because we fucking say transferred because it's fucking UCMS. We say transferred. We say transferred to Superior Court. This fucking test. It says transmitted. The felony complaint is promptly transmitted to the Superior Court. That means transmitted. I keep saying transferred because we fucking say transferred because it's fucking UCMS. We say transferred. We say transferred to Superior Court. This fucking test. It says transmitted. Transmitted. Apparently it's a freaking synonym for transferred, I guess. I don't know. Anyway, it's transmitted. And upon the court must inform him the charges against him immediately. And an immediate hearing has to be done. And to determine whether the defendant is to be held for the action of grand jury. How did I fucking know that shit? Upon a single judge trial of an information, if the information contains more than one count, the court must render a verdict upon each count not previously dismissed. Each count not previously dismissed. If a verdict which does not so dispose of each count, upon a single judge trial of an information, constitutes a verdict of not guilty as to each undisposed count, which does not so dispose of each count, constitutes a verdict of not guilty as to each undisposed count. Judge has to make a verdict on each count that wasn't previously dismissed. A verdict which does not so dispose of each count constitutes a verdict of not guilty as to each undisposed count. In general, the defendant must be personally present at the time of sentence is pronounced. Time sentence is pronounced. Exception where sentence is to be pronounced for a misdemeanor or for a petty offense. The court may, on motion of the defendant, dispense with the requirement the defendant be personally present. Any such motion must be accompanied by a waiver signed by the defendant reciting A, the maximum sentence that may be imposed. Jesus Christ. According to the criminal procedure law, the court may terminate a sentence of lifetime probation, but only if a person has been on unrevoked probation for at least 5 consecutive years. A defendant convicted of a Class A felony may have bail fixed by... This is one where if you knew too much, you got it wrong. It should have said in general. Generally, a defendant convicted of a Class A felony may have bail fixed by... Recognizance or bail may not be fixed upon conviction of a Class A felony. And that's in general. That's what the stupid question should have said. Court, upon motion of the people, may set aside a sentence upon the ground that the sentence was invalid as a matter of right. Such action must occur not more than 1 year after entry of the judgment. I should watch this stupid 440 video. 51. Upon an application for recognizance or bail, the court must take into consideration and into account 1. The principal's criminal record, if any. 2. The principal's record of responding to the court appearances. 3. The weight of evidence against the principal. And 4. The sentence which may be imposed. Again, upon an application for recognizance or bail, the court must take into consideration and into account the principal's criminal record, if any, the principal's record of responding to court appearances, the weight of evidence against the principal, and the sentence which may be imposed. 7. According to the criminal procedure law, a psychiatric examiner is a qualified psychiatrist or a certified psychologist designated by a director to examine a defendant pursuant to an order of examination, which is 30 days, remember that. Such examiner is entitled to a fee of $50 for each examination and $50 for each court visit. Such payment shall not exceed $200 in any one case. Shall not exceed $200 in any one case. $200, not exceed $200. The 30 days is the examination order. I never even saw this anywhere, and I freaking did this stupid article. When an incapacitated person is in the custody of the commissioner pursuant to an order of commitment or to orders of retention, the aggregate of the periods must not exceed more than 2/3 of the authorized maximum term of imprisonment for the highest class felony charge or for the highest class felony of which he was convicted. A person committing the violation of driving while impaired, traffic infraction punishable by a fine of not less than $300 and no more than 15 days in jail. A sentence to pay a fine shall be a sentence to pay an amount not exceeding $5,000 or twice the gain for a felony, or the fines for the misdemeanors, or twice the gain. I don't know why. I didn't remember that. $1,000 for a misdemeanor, $500 for a beat, and $250 for a misdemeanor, or twice the gain, not more than exceeding any of that shit.